Waiver of right to present evidence. Q. Carlos filed a complaint against Pedro in the RTC of Osamis City for the recovery of the ownership of a car. Pedro filed his answer within the regulatory period, after the pre-trial and actual trial, and after Carlos has completed the presentation of his evidence. Pedro moved for the dismissal of the complaint on the ground that under the facts proven and under the law applicable to the case, Carlos is not entitled to the ownership of the car. The RTC granted the motion for dismissal. Carlos appealed the order of dismissal, and the appellate court reversed the order of the trial court. Thereafter, Pedro filed a motion with the RTC asking the latter to allow him to present his evidence. Carlos objected to the presentation of evidence by Pedro. Should the RTC grant Pedro's motion to present evidence? Why? 2001 Bar. Answer: no. Pedro's motion should be denied. He can no longer present evidence. The rules provide that if the motion for dismissal granted by the trial court, but not on appeal, the order of dismissal is reversed, he shall be deemed to have waived the right to present evidence. Rule 33, Section 1. Demurrer to evidence in a civil case versus demurrer to evidence in a criminal case. Q. Compare the effects of denial of demurrer to evidence in a civil case with those of a denial of demurrer to evidence in a criminal case, 2003. In a civil case, the defendant has the right to file a demurrer to evidence without leave of court. If his demurrer is denied, he has the right to present evidence. If his demurrer is granted and on appeal by the plaintiff, the appellate court reverses the order and renders judgment for the plaintiff. The defendant loses his right to present evidence. Rule 33. In a criminal case, the accused has to obtain leave of court to file a demurrer to evidence. If he obtains leave of court and his demurrer to evidence is denied, he has the right to present evidence in his defense. If his demurrer to evidence is granted, he is acquitted and the prosecution cannot appeal. If the accused does not obtain leave of court and his demurrer to evidence is denied, he waives his right to present evidence and the case is decided on the basis of the evidence for the prosecution. The court may also dismiss the action on the ground of insufficiency of the evidence on its own initiative after giving the prosecution the opportunity to be heard. Section 23, Rule 119. Q. Ernie filed a petition for guardianship over the person and properties of his father, Ernesto. Upon receipt of the notice of hearing, Ernesto filed an opposition to the petition. Ernie, before the hearing of the petition, filed a motion to order Ernesto to submit himself for medical and physical examination, which the court granted. After Ernie's lawyer completed the presentation of evidence in support of the petition and the court's ruling on the formal offer of evidence, Ernesto's lawyer filed a demurrer to evidence. Ernesto's lawyer objected on the ground that a demurrer to evidence is not proper in a special proceeding. Was Ernie's counsel objection proper? 2015. No. The rule on demurrer to evidence is applicable in special proceedings. Matute v. Court of Appeals, GR 26751. Moreover, under Section 2, Rule 72 of the Rules of Court, in the absence of special rules, the rules provided for in ordinary actions shall be applicable as far as practicable to special proceedings. Judgment and final orders. Q. What is the difference between a judgment and an opinion of the court, 2006? A. The judgment, or fallo, is the final disposition of the court, which is reflected in the dispositive portion of the decision, while the opinion of the court is contained in the body of the decision that serves as a guide or enlightenment to determine the ratio decidendi of the decision. Judgment on the pleadings. Q. What are the grounds for judgment on the pleadings? 1999. A. The grounds for judgment on the pleadings are A. Where an answer fails to tender an issue, or B. Otherwise admits the material allegations of the adverse party's pleading. Section 1, Rule 34. Q. A's answer admits the material allegations of B's complaint. May the court motu proprio render judgment on the pleadings? Explain. 1999. No. A motion must be filed by the adverse party, Section 1, Rule 34. The court cannot motu proprio render judgment on the pleadings. Q. A. Brought an action against her husband B for annulment of their marriage on the ground of psychological incapacity. B filed his answer to the complaint admitting all the allegations therein contained. May A move for judgment on the pleadings? Explain, 1999. A. No, because even if B's answers to A's complaint annulment of their marriage admits all the allegations therein contained, the material facts alleged in the complaint must always be proved. Section 1, Rule 34. The court shall order the prosecutor to investigate whether or not a collusion between the parties exists, and if there is no collusion, to intervene for the state in order to see to it that the evidence submitted is not fabricated. Section 3, letter E, Rule 9. Evidence must have to be presented in accordance with the requirements set down by the Supreme Court in Republic v. Court of Appeals in Molina, GR 1087-63, 1997. Q. In a complaint for recovery of real property, the plaintiff averred, among others, that he is the owner of the said property by virtue of a deed of sale executed by the defendant in his favor. Copy of the deed of sale was appended to the complaint as Annex A thereof. In his unverified answer, the defendant denied the allegation concerning the sale of the property in question, as well as the appended deed of sale, for lack of knowledge or information sufficient to form a bulide as to the truth thereof. Is it proper for the court to render judgment without trial? Explain, 2005. A. Defendant cannot deny the sale of the property for lack of knowledge or information sufficient to form a bulide as to the truth thereof. The answer amounts to an admission. The defendant must aver or state positively how it is that he is ignorant of the facts alleged. Philippine Advertising Counselor versus Revilla. Moreover, the genuineness and due execution of the deed of sale can only be denied by the defendant under oath, and failure to do so is also an admission of the deed. Section 8, Rule 8. Hence, a judgment in the pleadings can be rendered by the court without need of a trial. Q. Plaintiff files a request for admission and serves the same on defendant who fails within the time prescribed by the rules to answer the request. Suppose the request for admission asked for the admission of the entire material allegations stated in the complaint. What should plaintiff do? 2012. A. The plaintiff should file a motion for judgment on the pleadings because the failure of the defendant to answer a request for admission results to an implied admission of all the matters which an admission is requested. Hence, a motion for judgment on the pleadings is the appropriate remedy where the defendant is deemed to have admitted matters contained in the request for admission by the plaintiff. Rule 34 in connection with Section 2, Rule 26. Q. Plaintiff sued defendant for collection of $1 million based on the latter's promissory note. The complaint alleges, among others, 1. Defendant borrowed $1 million from plaintiff as evidenced by a duly executed promissory note. Number 2. The promissory note reads, Makati, Philippines, December 30, 2014. For value received from plaintiff, defendant promises to pay plaintiff $1 million for 12 months from the above indicated date without necessity of demand. Signed, defendant. A copy of the promissory note is attached as Annex A. Defendant in his verified answer alleged, among others, 1. Defendant specifically denies the allegation in paragraph 1 and 2 of the complaint, the truth being defendant did not execute any promissory note in favor of the plaintiff, or 2. Defendant has paid the $1 million claimed in the promissory note, Annex A, of the complaint, as evidenced by an acknowledgement receipt duly executed by plaintiff on January 30, 2015 in Manila with his spouse signing as witness. A copy of the acknowledgement receipt is attached as Annex 1 hereof. Plaintiff filed a motion for judgment on the pleadings on the ground that defendant's answer failed to tender an issue as the allegations therein on his defenses are shown for being inconsistent, hence no defense at all. Defendant filed an opposition claiming his answer tendered an issue. A. Is judgment on the pleadings proper? 2015. Answer: no. The judgment on the pleadings is not proper. Judgment on the pleading is proper only when the answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleadings. Section 1, Rule 34. When it appears, however, that not all the material allegations of the complaint were admitted in the answer, because some of them were either denied or disputed, and the defendant has set up certain special defenses which, if proven, would have the effect of nullifying plaintiff's main cause of action, judgment on the pleadings cannot be rendered. Philippine National Bank versus Aznar, GR 17-10-5. Clearly, since the defendant's verified answer specifically denied the execution of the promissory note or raised the affirmative of payment, judgment on the pleading is not proper. Q. Defendant filed a motion for summary judgment on the ground that there are no longer any triable genuine issues of facts. Should the court grant defendant's motion for summary judgment? 2015. A. No. The court should not grant the motion for summary judgment because the defense of payment is a genuine issue as to material fact that must be resolved by the court upon presentation of evidence. For a summary judgment to be proper, the movant must establish two requisites. A. There must be no genuine issue as to any material fact, except for the amount of damages. And B. The party presenting the motion for summary judgment must be entitled to a judgment as a matter of law. A genuine issue is an issue of fact which requires the presentation of evidence as distinguished from an issue which is sham, fictitious, contrived, or false claim. Relative thereto, when the facts pleaded by the parties are disputed or contested, proceedings for a summary judgment cannot take place of a trial. The evidence and record must be viewed in light most favorable to the party opposing the motion, who must be given the benefit of all favorable inferences as can reasonably drawn from the evidence. Smart Communications versus Aldecoa. Summary judgment versus judgment on the pleadings. Q. Royal Bank, Royal, filed a complaint for a sum of money against Irvin and Jude before the RTC of Manila. The initiatory pleading averred that on February 14, 2010, Irvin obtained a loan from Royal in the amount of $1 million, as evidenced by promissory note number 007 PN, signed by Irvin. Jude signed a surety agreement binding herself as surety for the loan. Royal made a final demand on February 14, 2015 for Irvin and Jude defendants to pay, but the latter failed to pay. Royal prayed that defendants Irvin and Jude be ordered to pay the amount of $1 million plus interest. In their answers, Irvin admitted that he obtained the loan from Royal and signed the promissory note. Jude also admitted that she signed the surety agreement. Defendants pointed out that promissory note did not provide the due date for payment and that the loan has not yet matured, as the maturity date was left blank to be agreed upon by the parties at a later date. Defendants filed a motion for a judgment on the pleadings on the ground that there is no genuine issue presented by the parties' submissions. Royal opposed the motion on the ground that the promissory note's maturity is an issue that must be thrashed out during trial. A. Resolve the motion with reasons. B. Distinguish summary judgment and judgment on the pleadings. Answer to letter A. The motion for judgment on the pleadings should be denied. First, judgment on the pleadings is available to the plaintiff and not to the defendant. Second, judgment on the pleadings is proper only when the answer fails to tender any issue. That is, if it does not deny the material allegations in the complaint or admits said material allegations of the adverse party's pleadings by admitting the truthfulness thereof and or omitting to deal with them at all. Here, while the defendant's answer to the complaint practically admitted all the material allegations therein, it nevertheless asserts the affirmative defenses that the loan is not yet due. As issues obviously arise from these affirmative defenses, a judgment on the pleadings is clearly improper in this case. Besides, It should be emphasized that judgment on the pleadings is based exclusively upon the allegations appearing in the pleadings of the parties and the annexes, if any, without consideration of any evidence aliunde. Henceforth, when it appears that not all the material allegations of the complaint were admitted in the answer, for some of them were either denied or disputed, and the defendant has set up certain special defenses, which, if proven, would have the effect of nullifying plaintiff's main cause of action, judgment on the pleadings cannot be rendered. Philippine National Bank versus Remedial Law Bar. Letter B. What distinguishes a judgment on the pleadings from a summary judgment is the presence of issues in the answer to the complaint. When the answer fails to tender any issues, that is, if it does not deny the material allegations in the complaint or admits said material allegations of the adverse party's pleading by admitting the truthfulness thereof and or omitting to deal with them at all, a judgment on the pleadings is appropriate. On the other hand, when the answer specifically denies the material averments of the complaint or asserts affirmative defenses, or in other words, raises an issue, a summary judgment is proper, provided that the issue raised is not genuine. A genuine issue means an issue of fact which calls for the presentation of evidence, as distinguished from an issue which is fictitious or contrived, or which does not constitute a genuine issue for trial. Eugenio Baspas versus Pieta Saison and Roberto Saison Jr. Post-judgment remedies. Motion for a new trial or reconsideration. Q. The RTC rendered judgment against ST, a copy of which was received by his counsel on February 28, 2000. On March 10, 2000, ST through counsel filed a motion for reconsideration of the decision with notice to the clerk of court submitting the motion for the consideration of the court. On March 15, 2000, realizing that the motion lacked a notice of hearing, ST's counsel filed a supplemental pleading. Was the motion for reconsideration filed with the reglementary period? 2000. Yes, because the last day of filing a motion for reconsideration was March 15 if February had 28 days, or March 16 if February had 29 days. Although the original motion for reconsideration was defective because it lacked a notice of hearing, the defect was cured on time by its filing on March 15 of a supplemental hearing, provided that motion was set for hearing and served on the adverse party at least 3 days before the date of hearing. Section 4, Rule 15. Matters not appealable. Q. What is an interlocutory order? 2006. A. An interlocutory order is an order which decides some point or matter between the commencement and end of the suit, but it is not the final decision on the whole controversy. It leaves something to be done by the court before the case is finally decided on the merits. Metropolitan Bank and Trust versus Court of Appeals. Q. After defendant has served and filed his answer to plaintiff complaint for damages before the proper RTC, plaintiff served and filed a motion with supporting affidavits for a summary judgment in his favor upon all of his claims. Defendant served and filed his opposition with supporting affidavits to the motion. After due hearing, the court issued an order stating that the court has found a genuine issue as to any material fact, and thus concluded that plaintiff is entitled to judgment in his favor as a matter of law, except as to the amount of damages recoverable, and 2, accordingly, ordering the plaintiff shall have judgment summarily against defendant for such amount as may be found due plaintiff for damages, to be ascertained by trial on October 7, 2004 at 8:30 o'clock in the morning. May defendant properly take an appeal from said order, or may defendant properly challenge said order to a special civil action for certiorari, 2004. A. No. Plaintiff may not properly take an appeal from said order because partial summary judgments are interlocutory orders. There is still something to be done, which is the trial for the adjudication of damages. Province of Pangasinan versus Court of Appeals. But the defendant may properly challenge said order to a special civil action for certiorari, Section 1, letter C, and last paragraph of Rule 41. Modes of appeal. Q. What are the modes of appeal to the Supreme Court 2002? The modes of appeal to the Supreme Court are A. Appeal by certiorari and pure questions of law under Rule 45 to a petition for review on certiorari, and B. Ordinary appeal in criminal cases to a notice of appeal from convictions imposing reclusion perpetua or life imprisonment, or where the lesser penalty is involved but for offenses committed on the same occasion or which arose out of the same occurrence that gave rise to the more serious offense. Section 3, Rule 122. Convictions imposing the death penalty are elevated to automatic review. Q. Distinguish the two modes of appeal from the judgment of the original trial court to the Court of Appeals. In cases decided by the regional trial courts and the exercise of their original jurisdiction, appeals to the Court of Appeals shall be ordinary appeal by filing written notice of appeal indicating the parties to the appeal, specifying the judgment or final order or part thereof appealed from, specifying the court to which the appeal is being taken, and stating the material dates showing the timelines of the appeal. The notice of appeal shall be filed with the RTC which rendered the judgment, appealed from, and copy thereof shall be served upon the adverse party within 15 days from notice of judgment or final order appealed from. But if the case admits of multiple appeals or is a special proceeding, a record on appeal is required aside from the written notice of appeal to perfect the appeal, in which case the period for appeal and notice upon the adverse party is not only 15 days but 30 days from notice of judgment or final order appealed from. The full amount of the appellate court docket fee and other lawful fees required must also be paid within the period for taking an appeal to the clerk of the court which rendered the judgment or final order appealed from. Sections 4 and 5, Rule 41. The periods of 15 or 30 days above stated are non-extendable. In cases decided by the regional trial court in the exercise of its appellate jurisdiction, appeal to the Court of Appeals shall be by filing a verified petition for review with the Court of Appeals and furnishing the RTC and the adverse party with copy thereof within 15 days from notice of judgment or final order appealed from. Within the same period for appeal, the docket fee and other lawful fees required with a deposit for cost should be paid. The 15-day period may be extended for 15 days and another 15 days for compelling reasons. Period for appeal. Q. Defendant X received an adverse decision of the RTC in an ordinary civil case on January 2, 2003. He filed a notice of appeal on 10 January 2003, filed a motion for reconsideration after the decision. On 13 January 2003, Defendant X filed a motion withdrawing his notice of appeal in order to file a motion for new trial, which he attached. On January 2003, the court denied A's motion to withdraw notice of appeal. Plaintiff A received the order denying his motion for reconsideration on February 3, 2003, and filed his notice of appeal on the 5th of February 2003. The court denied due course to A's notice of appeal on the ground that the period to appeal already lapsed. A. Is the court's denial of X motion to withdraw notice of appeal proper? A. No. The court's denial of X motion to withdraw notice of appeal is not proper because the period of appeal of X has not yet expired. From January 2, 2003, when X received a copy of the adverse decision of the January 13, 2003, when he filed his withdrawal of appeal and motion for a new trial, only 10 days had elapsed, and he then had 15 days to do so. B. Is the court's denial of due course to A's appeal correct? 2003. No, the court's denial of due course to A's appeal is not correct because the appeal was taken on time from January 6, 2003, when A received a copy of the decision of the January 19, 2003, when he filed a motion for reconsideration. Only 12 days had elapsed. Consequently, he had 3 days from receipt of February 2003 of the order denying his motion for reconsideration within which to appeal. He filed his notice to appeal February 5, 2003, or 2 days later. Note: to standardize the appeal periods provided in the rules and to afford litigants fair opportunity to appeal their cases, the court deems it practical to allow a fresh period of 15 days within which to file the notice of appeal in the RTC, counted from receipt of the order dismissing a motion for a new trial or motion for reconsideration. Napes et al. Versus Court of Appeals. Q. XXX received a copy of the RTC decision on June 9, 1999. YY received it on the next day, June 10, 1999. XXX filed a notice of appeal on June 15, 1999. The parties entered into a compromise on June 16, 1999. On June 13, 1999, YY, who did not appeal, filed with the RTC a motion for approval of the compromise agreement. XXX changed its mind and opposed the motion on the ground that the RTC has no more jurisdiction. Rule on the motion assuming that the records have not yet been forwarded to the CA. 1999 bar. A. The contention of XXX that the RTC has no more jurisdiction over the case is not correct, because at the time that the motion to approve the compromise had been filed, the period of appeal of YY had not yet expired. The records of the case had not yet been forwarded to the Court of Appeals. The rules provide that in appeals by notice of appeal, the court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. Section 9, third paragraph, Rule 41. The rules also provide that prior to the transmittal of the record, the court may, among others, approve compromises. Section 9, fifth paragraph, Rule 41. Perfection of appeal. Q. When is an appeal from RTC to the Court of Appeals deemed perfected? 1999. A. An appeal from the RTC to the Court of Appeals is deemed perfected as to the appellant upon the filing of a notice of appeal in the original trial court in due time or within the reglementary period of appeal. An appeal by record on appeal is deemed perfected as to the appellant with respect to the subject matter thereof upon the approval of the record on appeal filed in due time. Section 9, Rule 4. Appeals from judgments or final orders of the MTC, appeals from judgments or final orders of the RTC, appeals from judgment or final orders of the CTA. Q. Where and how will you appeal the following? A. An order of execution issued by the RTC. A petition for certiorari under Rule 65 before the Court of Appeals. B. Judgment of RTC denying a petition for writ of amparo. A. Any part may appeal from the final judgment or order to the Supreme Court by way of a petition for review on certiorari under Rule 45 of the Rules of Court. The period of appeal shall be 5 working days from the date of notice of the adverse judgment, and the appeal may raise questions of fact or law or both. Section 19, Rule on the Writ of Amparo, AM number 07-9-12, SC, September 25, 2007. C. Judgment of MTC on a land registration case based on its delegated jurisdiction. A. The appeal should be filed with the Court of Appeals by filing a notice of appeal within 15 days from notice of judgment or final order appealed from. Section 34, Batas Pambansa, Bilang 129, or the Judiciary Reorganization Act of 1980, as amended by Republic Act 7691, March 25, 1994. Letter D. A decision of the Court of Tax Appeals, First Division, 2012. The decision of the Court of Tax Appeals Division may be appealed to the CDA and Bank. the decisions of the Court of Tax Appeals are no longer appealable to the Court of Appeals. Under the modified appeal procedure, the decision of a division of the CDA may be appealed to the CDA en banc. The decision of the CDA en banc may in turn be directly appealed to the Supreme Court by way of a petition for review on certiorari under Rule 45 on questions of law, Section 11 RA 9282, March 30, 2004. Q. After receiving the adverse decision rendered against his client, the defendant, attorney Sikat, duly filed a notice of appeal. For his part, the plaintiff timely filed a motion for partial new trial to seek an increase in the monetary damages awarded. The RTC instead rendered an amended decision further reducing the monetary awards. Is it necessary for attorney Sikat to file a second notice of appeal after receiving the amended decision, 2008? A. Yes. It is necessary for attorney Sikat to file a second notice of appeal to the amended decision because a substantial change was made to the original decision when the monetary awards were reduced in the amended decision, and in effect, the amended decision superseded the original decision. A new notice of appeal is required to comply with the required contents thereof in respect of the amended decision. Pacific Life Assurance Corporation v. Season. Q. On July 15, 2009, Attorney Manananggal was served copies of numerous unfavorable judgments and orders. On July 29, 2009, he filed motions for reconsideration which were denied. He received the notices of denial of the motions for reconsideration on October 2, 2009, a Friday. He immediately informed his clients, who in turn uniformly instructed him to appeal. How, when, and where should he pursue the appropriate remedy for each of the following? A. Judgment from a municipal trial court pursuant to its delegated jurisdiction dismissing his client's application for land registration. A. By notice of appeal within 15 days from notice of judgment or final order appealed from to the Court of Appeals. Letter B. Judgment of the regional trial court denying his client's petition for a writ of habeas data. Answer: by verified petition for reviews on certiorari under Rule 45, with the modification that the appellant may raise questions of fact or law or both within 5 workdays from date of notice of the judgment or final order to the Supreme Court, Section 19, AM, number 08-1-16 SC. C. Order of a family court denying his client's petition for habeas corpus in relation to custody of a minor child. A. By notice of appeal within 48 hours from notice of judgment or final order to the Court of Appeals, Section 14, RA 8369, in relation to Section 3, Rule 41. Letter D. Order of the RTC denying his client's petition for certiorari questioning the Metropolitan Trial Court's denial of a motion to suspend criminal proceedings. A. By notice of appeal within 15 days from notice of the final order to the Court of Appeals by Estrada v. People. E. Judgment of the First Division of the Court of Tax Appeals affirming the RTC decision convicting his client for a violation of the National Internal Revenue Code, 2009. A. By petition for review filed with the Court of Tax Appeals en banc within 30 days from receipt of the decision or ruling in question, Section 9, Letter B, Rule 9, Revised Rules of Court of Tax Appeals. Relief from judgments, orders, and other proceedings, preliminary injunction pending proceedings. Q. Mike was renting an apartment unit in the building owned by Jonathan. When Mike failed to pay 6 months' rent, Jonathan filed an ejectment suit. The municipal trial court rendered judgment in favor of Jonathan, who then filed a motion for the issuance of a writ of execution. The MTC issued the writ. How can Mike stay the execution of the MTC judgment? Explain. A. Writ of execution shall be issued if immediately upon motion, unless Mike A. perfects his appeal to the RTC, B. files a sufficient supersedes bond to pay the rents, damages, and costs occurring up to the time of the judgment appealed from, and C. Deposits monthly with the RTC during the pendency of the appeal the amount of rent due from time to time, Section 19, Rule 70. B. Mike appealed to the RTC, which affirmed the MTC decision. Mike then filed a petition for review with the Court of Appeals. The CA dismissed the petition on the ground that the sheriff had already executed the MTC decision and had ejected Mike from the premises, thus rendering the appeal moot and academic. Is the CA correct? 2009. A. No, the Court of Appeals is not correct. The dismissal of the appeal is wrong because the execution of the RTC judgment is only in respect of the eviction of the defendant from the leased premises. Such execution pending appeal has no effect on the merits of the ejectment suit, which still has to be resolved in the pending appeal. Section 21, Rule 70 of the rules provides that the RTC judgment against the defendant shall be immediately executory, without prejudice to a further appeal that may be taken therefrom. Uy v. Santiago, July 31, 2000. Q. Having obtained favorable judgment in his suit for a sum of money against Patricio, Orencio sought the issuance of a writ of execution. When the writ was issued, the sheriff levied upon a parcel of land that Patricio owns, and a date was set for the execution sale. A. How may Patricio prevent the sale of the property on execution? A. Patricio may file a petition for relief with preliminary injunction, Rule 38, posting a bond equivalent to the value of the property levied upon, or assail the levy as invalid if ground exists. Patricio may also simply pay the amount required by the writ and the cost incurred therewith. Letter B. If Orencio is the purchaser of the property at the execution sale, how much does he have to pay? Explain. A. Orencio, the judgment creditor, should pay only the excess amount of the bid over the amount of the judgment if the bid exceeds the amount of the judgment. If the property is sold to a third party at the execution sale, what can Patricio do to recover the property? 2009. Patricio can exercise his right of legal redemption within 1 year from date of registration of the certificate of sale by paying the amount of the purchase price with interest of 1% monthly, plus assessment and taxes paid by the purchaser with interest thereon at the same rate. Q. A default judgment was rendered by the RTC ordering D to pay P a sum of money. The judgment became final, but D filed a petition for relief and obtained a writ of preliminary injunction staying the enforcement of the judgment. After hearing, the RTC dismissed D's petition, whereupon P immediately moved for the execution of the judgment in his favor. Should P's motion be granted? Y. 2002. A. P's immediate motion for execution of the judgment in his favor should be granted because the dismissal of this petition for relief also dissolves the writ of preliminary injunction staying the enforcement of the judgment, even if the dismissal is not yet final. Gaules v. Leonidas. Q. After his properties were attached, defendant Porfirio filed a sufficient counter bond. The trial court discharged the attachment. Nonetheless, Porfirio suffered substantial prejudice due to the unwarranted attachment. In the end, the trial court rendered a judgment in Porfirio's favor by ordering the plaintiff to pay damages because the plaintiff was not entitled to the attachment. Porfirio moved to charge the plaintiff's attachment bond. The plaintiff and his sureties opposed the motion, claiming that the filing of the counter bond had relieved the plaintiff's attachment bond from all liability for the damages. Rule on Porfirio's motion, 2008. A. Porfirio's motion to charge plaintiff attachment bond is proper and can be granted. It is not correct to contend that Porfirio's filing of a counter bond constitute a waiver of his right to proceed against the attachment bond for the damages he suffered from the unwarranted attachment. It is a condition inter alia of the applicant's attachment bond that he will pay all the costs which may be adjudged to the adverse party and all damages which the latter may sustain by reason of the attachment, if the court shall finally adjudge that the applicant was not entitled thereto. Section 4, Rule 57. DM Wenceslao and Associates versus Redicon Trading and Construction, June 29, 2004. Time to file the petition. May an order denying the probate of a will still be overturned after the period to appeal therefrom has lapsed? 2002. Yes, an order denying the probate of a will may be overturned after the period to appeal therefrom has lapsed. A petition for relief may be filed on the grounds of fraud, accident, mistake, or excusable negligence within a period of 60 days after the petitioner learns of the judgment or final order, and not more than 6 months after such judgment or final order was entered. Sections 1 and 3, Rule 38, Soriano v. Assi. An action for annulment may also be filed on the ground of extrinsic fraud within 4 years from its discovery, and if based on lack of jurisdiction before it is barred by laches or estoppel. Section 2 and 3, Rule 47. Annulment of judgments or final orders and resolutions. Grounds of annulment. Q. What are the grounds for the annulment of a judgment of the RTC, 1998? The grounds for annulment of judgment of the Regional Trial Court are extrinsic fraud and lack of jurisdiction. Section 2, Rule 47. Q. Tom Wallace filed with the RTC a petition for a declaration of nullity of his marriage with Debbie Wallace on the ground of psychological incapacity of the latter. Before filing the petition, Tom Wallace had told Debbie Wallace that he wanted annulment of their marriage because he was already fed up with her irrational and eccentric behavior. However, in the petition for a declaration of nullity of marriage, the correct residential address of Debbie Wallace was deliberately not alleged, and instead, the resident address of their married son was stated. Summons were served by substituted service at the address stated in the petition. For failure to file an answer, Debbie Wallace was declared in default and Tom Wallace presented evidence ex parte. The RTC rendered judgment declaring the marriage null and void on the ground of psychological incapacity of Debbie Wallace. 3 years after the RTC judgment was rendered, Debbie Wallace got a hold of a copy thereof and wanted to have the RTC judgment reversed and set aside. If you were the lawyer of Debbie Wallace, what judicial remedy or remedies will you take? Discuss and specify the grounds or grounds for said remedy or remedies. 2014. A. Debbie Wallace may file a petition for annulment of judgment under Rule 47 of the Rules of Court on the grounds of lack of jurisdiction, extrinsic fraud, and denial of the right to due process. Leticia Diona v. Romeo Balange. An action for annulment of judgment is a remedy in law independent of the case where the judgment sought to be annulled was rendered. The purpose of such action is to have the final and executory judgment set aside so that there will be a renewal of litigation. It is resorted to in cases where the ordinary remedies of new trial, appeal, petition for relief from judgment, or other appropriate remedies are no longer available through no fault of the appellant and is based on the grounds of extrinsic fraud and lack of jurisdiction. Sullivan v. Court of Appeals. Relative thereto, the act of Tom Wallace in deliberately keeping Debbie Wallace away from the court by intentionally alleging a wrong address in the complaint constitutes extrinsic fraud. Moreover, the failure of the court to acquire jurisdiction over the person of the respondent, being an indispensable party, necessitates the annulment of judgment of the Regional Trial Court. Likewise, there is denial of the right to due process when Debbie Wallace was not given an opportunity to be heard in the case. Hence, the judgment rendered by the RTC may be annulled by the Court of Appeals under Rule 47 of the Rules of Court. Moreover, it is evident that the ordinary remedies of new trial, petition for relief, or other appropriate remedies are no longer available through no fault of Debbie Wallace, because she was able to obtain a copy of the decision only 3 years after the same was rendered by the trial court. At any rate, the court erred in declaring the defendant in default because there is no default in a petition for declaration of nullity of marriage. Section 3, Rule 9. Thus, a petition for certiorari under Rule 65 of the Rules of Court could have been an appropriate remedy within the reglementary period allowed by the rules. Execution, satisfaction, and effects of judgment. Q. The writ of execution was returned unsatisfied. The judgment obligee subsequently received information that a bank holds a substantial deposit belonging to the judgment obligor. If you were the counsel of the judgment obligee, what steps would you take to reach the deposit to satisfy the judgment? A. Since the writ of execution is valid for 5 years from its issuance, the sheriff should be informed and requested to garnish or levy on execution the bank deposits belonging to the judgment obligor. Section 9, letter C, Rule 39. Then the judgment creditor move for a court order directing the application of such bank deposit to the satisfaction of the judgment. Section 40, Rule 39. B. If the bank denies holding the deposit in the name of the judgment obligor, but your client's informant is certain that the deposit belongs to the judgment obligor under an assumed name, what is your remedy to reach the deposit? 2008. A. To reach the bank deposit belonging to the judgment obligor, but under an assumed name, a motion may be filed for a court order requiring the proper bank officer to appear in court for examination under oath as to such bank deposit, and subsequently move for a court order authorizing the filing of an action against such bank for the recovery of the judgment obligor's deposit or interest therein, and to forbid a transfer or other disposition of such deposit or interest within 120 days from notice of the order. Sections 37 and 43, Rule 39. Q. A resident of Dagupan City secured a favorable judgment in an ejectment case against X, a resident of Quezon City, from the MTC of Manila. The judgment entered on 15th of June 1991 had not as yet been executed. In July 1996, I decided to enforce the judgment of the MTC of Manila. What is the procedure to be followed by A in enforcing the judgment? A can enforce the judgment by another action reviving the judgment because it can no longer be enforced by motion, as the 5-year period within which a judgment may be enforced by motion has already expired. Section 6, Rule 39. B. With what court should A institute the proceedings? 1997. A may institute the proceedings in the regional trial court in accordance with the rules of venue because the enforcement of the judgment is a personal action incapable of pecuniary estimation. Q. The trial court rendered judgment ordering the defendant to pay the plaintiff moral and exemplary damages. The judgment was served on the plaintiff on October 1, 2001, and on the defendant on October 5, 2001. On October 8, 2001, the defendant filed a notice of appeal from the judgment, but the following day, October 9, 2001, the plaintiff moved for the execution of the judgment pending appeal. The trial court granted the motion upon the posting by the plaintiff of a bond to indemnify the defendant for damages it may suffer as a result of the execution. The court gave as a special reason for its order the imminent insolvency of the defendant. Is the order of the execution pending appeal correct? Why? 2002. A. No, because awards for moral and exemplary damages cannot be the subject of execution pending appeal. The execution of any award for moral and exemplary damages is dependent on the outcome of the main case. Liabilities for moral and exemplary damages, as well as the exact amounts, remain uncertain and indefinite pending resolution by the Court of Appeals or Supreme Court. RCPI v. Lantin. International School v. Court of Appeals. Q. Aldrin entered into a contract to sell with Neil over a parcel of land. The contract stipulated a 500,000 pesos down payment upon signing the balance, payable in 12 months, the installment of 100,000 pesos. Aldrin paid the down payment and had paid 3 monthly installments when he found out that Neil had sold the same property to Yuri for 1.5 million, paid in cash. Aldrin sued Neil for specific performance with damages with the RTC. Yuri, with leave of court, filed an answer in intervention as he had already obtained the TCT in his name. After trial, the court rendered judgment ordering Aldrin to pay all the installments due, the cancellation of Yuri's title, and Neil to execute a deed of sale in favor of Aldrin. When the judgment became final and executory, Aldrin paid Neil all the installments, but the latter refused to execute the deed of sale in favor of the former. Aldrin filed a petition for the issuance of a writ of execution with proper notice of hearing. The petition alleged, among others, that the decision had become final and executory, and he is entitled to the issuance of the writ of execution as a matter of right. Neil filed a motion to dismiss the petition on the ground that it lacked the required certification against forum shopping. A. Should the court grant Neil's motion to dismiss 2015? Answer: no. The motion to dismiss should be denied because the certification against forum shopping is only required in the complaint or other initiatory pleading, Section 5, Rule 7, Arquisa versus Court of Appeals. Since a petition for the issuance of the writ of execution is not an initiatory pleading, it does not require a certification against forum shopping. Q. Despite the issuance of the writ of execution directing Neil to execute the deed of sale in favor of Aldrin, the former obstinately refused to execute the deed. What is Aldrin's remedy? 2015. Aldrin may move for the issuance of a court order directing the execution of the deed of sale by some other person appointed by it. Under Section 10, Rule 39 of the Rules of Court, if a judgment directs a party to execute a conveyance of land or personal property, or to deliver deeds, other documents, or to perform any other specific act in connection therewith, and the party fails to comply within the time specified, the court may direct the act to be done at the cost of the disobedient party by some other person appointed by the court, and the act when so done shall have like effect as if done by the party. If real or personal property is situated within the Philippines, the court, in lieu of directing a conveyance thereof, may be, by an order, divest the title of any party and vest it in others, which shall have the force and effect of a conveyance executed in due form of law. The phrase "some other person appointed by the court" may refer to the branch clerk of court, sheriff, or even the register of deeds, and their acts, when done under such authority, shall have the effect of having been done by Neil himself. Examination of judgment obligor when judgment is unsatisfied. Q. The plaintiff, a Manila resident, sued the defendant, a resident of Malolos, Bulacan, in the RTC, Manila, for a sum of money. When the sheriff tried to serve the summons with a copy of the complaint on the defendant at his Bulacan residence, the sheriff was told the defendant had gone to Manila for business and would not be back until the evening of that day. So the sheriff served the summons together with a copy of the complaint on the defendant's 18-year-old daughter, who was a college student. For the defendant's failure to answer the complaint within the reglementary period, the trial court, on motion of the plaintiff, declared the defendant in default. A month later, the trial court rendered judgment holding the defendant liable for the entire amount paid for in the complaint. A. After the judgment had become final, a writ of execution was issued by the court. As the writ was returned unsatisfied, the plaintiff filed a motion for an order requiring the defendant to appear before it and to be examined regarding his property and income. How should the court resolve the motion? A. The RTC Manila should deny the motion because it is in violation of the rule that no judgment obligor shall be required to appear before a court for the purpose of examination concerning his property and income, outside the province or city in which such obligor resides. In this case, the judgment obligor resides in Bulacan. Section 36, Rule 39. B. 7 years after the entry of judgment, the plaintiff filed an action for its revival. Can the defendant successfully oppose the revival of the judgment by contending that it is null and void because the RTC Manila did not acquire jurisdiction over his person? 2002. Yes, because the sheriff did not exert sufficient effort to serve summons personally on the defendant within a reasonable time, and hence the RTC Manila did not acquire jurisdiction over his person. Section 6 and 7, Rule 14, De Guzman v. Court of Appeals. Enforcement and effect of foreign judgment or final orders. Under Article 1144 of the new Civil Code, an action upon a judgment must be brought within 10 years from the time the right of action accrues. Is this provision applicable to an action filed in the Philippines to enforce a foreign judgment? Explain. 2005. No. Article 1144 of the Civil Code, which requires that an action upon a judgment, though without distinction, must be brought within 10 years from the time the right of action accrues, does not apply to an action filed in the Philippines to enforce a foreign judgment. While we can say that where the law does not distinguish, we should not distinguish, still the law does not evidently contemplate the inclusion of foreign judgments. A local judgment may be enforced by motion within 5 years and by action within the next 5 years. Rule 39. That is not the case with respect to foreign judgments, which cannot be enforced by mere motion. Provisional remedies. Q. The plaintiff obtained a writ of preliminary attachment upon a bond of 1 million. The writ was levied on the defendant's property, but it was discharged upon the posting of the defendant a counter bond in the same amount of 1 million. After trial, the court rendered judgment finding that the plaintiff had no cause of action against the defendant and that he had sued out the writ of attachment maliciously. Accordingly, the court dismissed the complaint and ordered the plaintiff and its surety to pay jointly to the defendant 1.5 million as actual damages, 0.5 million as moral damages, and 0.5 million as exemplary damages. Evaluate the soundness of the judgment from the point of view of procedure. 2002. The judgment against the surety is not sound if due notice was not given to him of the applicant for damages. Section 20, Rule 57. Moreover, the judgment against the surety cannot exceed the amount of its counter bond of 1 million. Q. In a case, the property of an incompetent under guardianship was in custodia legis. Can it be attached? 1999. Although the property of an incompetent under guardianship is in custodia legis, it may be attached, as in fact it is provided that in such case a copy of the writ of attachment shall be filed with the proper court and notice of the attachment served upon the custodian of such property. Section 7, last paragraph, Rule 57. Q. May damages be claimed by a party prejudiced by a wrongful attachment even if the judgment is adverse to him? 1999. Yes. Damages may be claimed by a party prejudiced by a wrongful attachment even if the judgment is adverse to him. This is authorized by the rules. A claim for damages may be made on account of improper, irregular, or excessive attachment, which shall be heard with notice to the adverse party and his surety or sureties. Section 20, Rule 57. Javellana v. D.O. Plaza Enterprises. May a writ of preliminary attachment be issued ex parte? Briefly state the reasons for your answers. 2001. Yes, an order of attachment may be issued ex parte, or upon motion with notice and hearing. Section 2, Rule 57. The reason why the order may be issued ex parte is that requiring notice to the adverse party and a hearing would defeat the purpose of the provisional remedy and enable the adverse party to abscond or dispose of his property before a writ of attachment issues. Mindanao Savings and Loan Association versus Court of Appeals. May a preliminary injunction be issued ex parte? 2001. No. A writ of preliminary injunction may not be issued ex parte. As provided in the rules, no preliminary injunction shall be granted without hearing and prior notice to the party or person sought to be enjoined. Section 5, Rule 58. The reason is that a preliminary injunction may cause grave and irreparable injury to the party enjoined. Q. Caddy filed an action against Tyrone for collection of the sum of $1 million in the RTC with an ex parte application for a writ of preliminary attachment. Upon posting of an attachment bond, the court granted the application and issued a writ of preliminary attachment. Apprehensive that Tyrone might withdraw his savings deposit with the bank, the sheriff immediately served a notice of garnishment on the bank to implement the writ of preliminary attachment. The following day, the sheriff proceeded to Tyrone's house and served him the summons, with copies of the complaint containing the application for writ of attachment, Caddy's affidavit, order of attachment, writ of preliminary attachment, and attachment bond. Within 15 days from service of the summons, Tyrone filed a motion to dismiss and to dissolve the writ of preliminary attachment on the following grounds. 1. The court did not acquire jurisdiction over his person because the writ was served ahead of the summons. 2. The writ was improperly implemented. And 3. Said writ was improvidently issued because the obligation in question was already fully paid. Resolved the motion with reasons 2005. The motion to dismiss and to dissolve the writ of preliminary attachment should be denied. 1. The fact that the writ of attachment was served ahead of the summons did not affect the jurisdiction of the court over his person. It makes the writ unenforceable. Section 5, Rule 57. However, all that is needed to be done is reserve the writ Onate versus Abrogar. Number 2. The writ was improperly implemented. Serving a notice of garnishment, particularly before the summons is served, is not proper. It should be a copy of the writ of attachment that should be served on the defendant and a notice that the bank deposits are attached pursuant to the writ. Section 7, letter D, Rule 57. Number 3. The writ was improvidently issued. If needed, it can be shown that the obligation was already fully paid. The writ is also ancillary to the main action. Section 13, Rule 57. The alleged payment of the account cannot serve as a ground for resolving the improvident issuance of the writ because this matter delves into the metrics of the case and requires full-blown trial. Payment, however, serves as a ground for a motion to dismiss. Q. Distinguish attachment from garnishment, 1999. Attachment and garnishment are distinguished from each other as follows. Attachment is a provisional remedy that affects a levy on property of a party as security for the satisfaction and judgment that may be recovered, while garnishment is a levy on debts due the judgment obligor or defendant and other credits, including bank deposits, royalties, and other personal property not capable of manual delivery under a writ of execution or a writ of attachment. Q. Briefly discuss or differentiate the following kinds of attachment: preliminary attachment, garnishment, levy on execution, warrant of seizure, and warrant of distraint and levy, 2012. Preliminary attachment is a provisional remedy under Rule 57 of the Rules of Court. It may be sought at the commencement of an action or at any time before entry of judgment where property of an adverse party may be attached as security for satisfaction of any judgment, where this adverse party is about to depart from the Philippines, where he has intent to defraud or has committed fraud, or is not found in the Philippines. An affidavit and a bond is required before the preliminary attachment issues. It is discharged upon payment of a counter bond. Garnishment is a matter of satisfying or executing judgment where the sheriff may levy debts, credits, royalties, commissions, bank deposits, and other personal property not capable of manual delivery that are in the control or possession of a third person and are due the judgment obligor. Notice shall be served on third parties The third-party garnishee must make a written report on whether or not the judgment obligor has sufficient funds or credit to satisfy the amount of the judgment. If not, the report shall state how much funds or credits the garnishee holds for the judgment obligor. Section 9, letter C, Rule 39. Warrant of seizure is normally applied for with a search warrant in criminal cases. The warrant of seizure must particularly describe the things to be seized. While it is true that the property to be seized under a warrant must be particularly described therein, and no other property can be taken thereunder, yet the description is required to be specific only insofar as the circumstances will ordinarily allow. An application for search and seizure warrant shall be filed with the following: A. Any court within whose territorial jurisdiction a crime was committed. B. For compelling reasons stated in the application, any court within the judicial region where the crime was committed, if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if the criminal action has already been filed, the application shall only be made in the court where the criminal action is pending. Warrant of distraint and levy is remedy available to local governments and the BIR in tax cases to satisfy deficiencies or delinquencies in inheritance and estate taxes and real estate taxes. Distraint is the seizure of personal property to be sold in an authorized auction sale. Levy is the issuance of a certification by the proper officer showing the name of the taxpayer and the tax, fee, charge, or penalty due him. Levy is made by writing upon said certificate the description of the property upon which levy is made.